Good morning, ladies and gentlemen. My name is Amanda Nelson. I'm the National Coordinator for the Stetson Environmental Moot competition. I warmly welcome you guys to this occasion. Today, it's my great pleasure, to welcome you all to the Ghana National Round of the 30th Annual Stetson International Environmental Moot Court competition. Today marks an important moment, not only for the participating teams, but also for the continued growth of environmental law advocacy in Ghana. Moot is recognized globally as the premier competition in international environmental law, and we are proud to host the Ghana Rounds here in GIMPA today. This competition challenges students to think critically about the most pressing environmental issues of our time. Beyond legal knowledge, it tests research skills, teamwork, written advocacy, and oral persuasions, which are all essentials as lawyers. To the participating teams, I commend the hard work and dedication you invested in preparing for today's competition. Mooting at this level requires discipline, resilience, and courage. Today, you are not just representing your institutions, but you are contributing to the development of environmental law advocacy in Ghana. To our distinguished guests who are not here, who are not here, they are in the next room. Thank you for generously offering your time and your expertise. Your role is vital in shaping the experience of these students, and we are deeply appreciative of your commitment to the nurturing of the next generation. We also like to acknowledge the support of GIMPA in hosting us, and also our headline sponsors, which is ADO and legal attorneys. Thank you very much for being here, and we appreciate your support today. Please let us all pay attention to what will be happening here today, because it is very important. Environmental law is key to Ghana. Our environment is very key to us, so let us all take a key part, because in future we could be environmental lawyers, and it will be important to us. Thank you very much. Please, we'll be starting the round soon. We will have the judges coming, so I'm handing over to the bailiffs.
President and Excellencies of the Court, may it please the Court, I am Darren Foster Mensah, appearing as agent on behalf of the applicant in the matter before the Court today, Team 003A. If the Court may so please, I shall proceed with the statement of issues, otherwise with the fact before the Court. The fact before the Court today, the case concerns the royal panther, which is a species which has been extinct for about 6,000 years. And in this 6,000 years, recently in 2009, biological specimens were found in an aquarium. This biological species was loaned to Redus in 2009 for the purposes of educational and scientific research. However, I will plead to handle issues 1 and 2 with an allocated time of 15 minutes. Co-agent would use 10 minutes for issues 3 and 4, and we plead 5 minutes for rebuttal. If the Court will permit, I'll proceed with issue 1. On the first issue, we have 4 substantive arguments before the Court. The first is that the genetic material originated in an aquarium, thus triggering prior informed consent obligations. The second is that the CBD entrenches state sovereignty over genetic resources. The third is that the loan agreement did not constitute informed consent for de-extinction purposes. And 4, that Redus's reliance on transboundary species status is misplaced. On the first argument, now we know that under Article 6.1 of the Nagoya Protocol, access to genetic resources is subject to the prior informed consent of the party providing such resources. Now, the CBD elaborates or defines a country providing genetic resources, as I quote, the country supplying such resources collected from in situ sources. In this case, Anekoyon was the territorial originator of the fossil by virtue of the fact that the fossil was discovered on Anekoyon soil. Now, this leads to another argument that if perchance these biological materials or these fossils that were found in Anekoyon soil have been extinct for 6,000 years, could then qualify as biological species? We answer yes. For the purposes of the fact that DNA extraction could be made possible from these fossils, it means that they contain active biological material, which puts them under the purview of the definition in the CBD and the Nagoya Protocol. Again, there's an argument as well that Redus does not fall under the purview of the Nagoya Protocol because the Nagoya Protocol came into force in 2015, while the loan agreement for the loan of the biological material or the fossil to Redus was done in 2009. To this, we argue to the effect that we are not arguing on the transfer of the biological material, but we are arguing on the utilization of the biological material, which started from the process of extraction of DNA sequences from the biological material. On to our second issue. On to our second argument under the first issue. We argue as well that the CBD's foundational structure is based on the principle of national sovereignty. Under Article 3, it affirms that states have the sovereign right to exploit their own resources pursuant to their own environmental policies. Article 15.1 further provides that the authority to determine access to genetic resources is subject to the national legislation of the government, and this language, as here input, is unambiguous and is very frank. It states that as the territorial originator of the fossil in question, the applicant has territorial jurisdiction over it, and therefore, Redus in its utilization of the fossilized material ought to seek the prior informed consent of the applicant in today's matter. On our third argument, we argue that the original loan agreement which was given to Redus was for the purposes of educational and scientific research. To this effect, we wish to evoke the CBD's bond guidelines and the Nagoya Protocol Implementation Guide, which states it clear that for prior informed consent, there must be specificity of the rationale for the consent being sought. So, for example, if we are going on for an argument, and if we are going on, for example, a loan or something, we dictate and we make it explained the reasons for the loan, and we take the loan and we act according to the purview of the loan agreement which we put. In this case, Redus has stretched his IT hands into another purview, which is de-extinction processes. Now, this begs another question that if this de-extinction process, can it be labeled as scientific research? We argue no. Due to the clause of specificity which has been placed upon there, research ends at the point where we are studying about the material instead of going ahead to put active effort in place to revive the material. That is in two different ball games by virtue of the fact of the procedures and processes used to revive or to bring life back into a material which has been extinct for 6,000 years. On to our fourth argument. Redus invokes Article 11 of the Nagoya Protocol, which argues that the species is a transboundary species. A transboundary species is a species which has, for a moment in time or a place in brief history, has been on either one part of the land and another part of the land. We argue to this effect that under Article 2 of the CBD, and I quote, country providing genetic resources means the country supplying genetic resources collected from in situ sources, including populations of both wild and domesticated species, or taken from ex situ sources, which may or may not have originated in that country. Emphasis added on may or may not have originated in that country. To this, we argue that if in this case, even if the fossilized material was not found in Anekoyon, by virtue of the was not necessarily a transboundary species, or whether it was, by virtue of the fact that it was found on Anekoyan soil, Anekoyon exercises territorial sovereignty and jurisdiction over the fossilized material, which brings us back to the point that the respondent in today's matter ought to seek the informed consent of Anekoyon before beginning any processes with regard to the biological material. And this brings another question. If Redus found it necessitative to go into a loan agreement before beginning such scientific and educational research, why then could they not come back again to ask for informed consent when they wanted to begin the process of de-extinction, especially when Anekoyon voices objections from the beginning that they do not agree? And on the agreement, if the court will so permit, I shall move on to issue 2 to explain further. Much obliged. On issue 2, we respectfully submit that the refusal of the applicant to grant prior informed consent for the de-extinction of the royal panther is a lawful and principled exercise of our sovereign right under the Convention on Biological Diversity, and it is far from undermining the CBD's objectives. To this effect, we have 4 major arguments. The first is that the CBD entrenches state sovereignty over genetic resources and guarantees a right to refusal of any such authentication sought from the country. On the second, we argue that the refusal is consistent with the CBD's objectives. On the third, we argue that the precautionary principle, according to Principle 15 of the Rio Declaration, justifies Anekoyon's refusal. And on the fourth, we argue that national legislation reflects the right to regulate access. On the first, there is no provision wherever and whatsoever in the CBD or the Nagoya Protocol that obligates a state to provide access to a material which has been found on their own soil. The right to refusal is inherent in each country's national jurisdiction. By the virtue of the fact that Anekoyon has refused to engage in any further deliberations on the matter with Redus, they are qualified to do so by virtue of the fact that they exercise national sovereignty and territorial integrity over the fossilized material. We argue as well on our second argument that the refusal is consistent with the CBD's objectives. Now, the CBD's objectives are threefold, as stated in Article 1 of the CBD. And it makes it clear that 1, there is the conservation of biological diversity. 2, the sustainable use of the components of biological diversity. And 3, fair and equitable sharing of benefits. And we argue that Anekoyon's refusal supports all 3. Before we proceed, I'd like to invoke Article 38 of this Noble Courts, the ICJ statute, to the effect that we are allowed to cite the work of published scholarly articles in our argument before this court. And to this effect, we argue, according to Redford et al. In his article, Synthetic Biology and the Conservation of Biodiversity. And he argues that de-extinction poses one significant risk. It risks shifting attention and funding away from urgent conservation efforts, which are supposed to be utilized to help to prevent the further extinction of animals or further extinction of plant resources and animal resources in the biosphere. On the second, that is on the sustainable use of the components, we argue, according to Ronald Sandler's article in the Ethics of Reviving Extinct Species, and he argues that the reintroduction, and this is our major fear, the reintroduction of long extinct species into modern ecosystems which have survived without them for a long period of time risks significant damage to the biosphere. In this case, we have the fossilized fuel, which has been out of extinction for a period of 6 millennia, that is 6,000 years. To reintroduce these species into the biosphere could pose significant risk to the current ecosystem, especially when the sufficient environmental impact assessments have not been done. To this effect, we recognize that yes, while Redus has done its due diligence in the effect of beginning with environmental impact assessments, we argue, according to this case, this court's decision in the Pulp Mills on River Yoruba case, that the consent which has been sought by virtue of the environmental impact assessment must be continuous. In this case, the only time when the environmental impact assessment was done was at the beginning of the research processes into the extraction of the biological material. So from that point up until the time where the biological material has been done, the panthers have been brought back to life and have been introduced into community in a zoo for people to watch and for people to pay money to be able to enjoy the view and enjoy biological diversity. There have been no further environmental impact assessments, and this creates significant damage to the biosphere by virtue of the fact that if we do not know about what the impact of the reintroduction of a species which has been extinct for 6,000 years has done to our current environment, how are we supposed to impose laws or to bring laws about that are going to help curb that? And that is our greatest fear as the applicant in today's matter. On to our next issue, we argue as well that national legislation reflects the right to regulate access. Now, Anekoyon, by virtue of it having territorial sovereignty over the fossilized fuel, enacted legislations to the purposes of preventing access to the utilization of the fossilized material. Now, Article 15.1 of the CBD supports this and quotes, and it explicitly allows parties to condition access to fossilized material or biological material found in their national jurisdiction under their national law. And Anekoyon has successfully invoked this. However, to utter dismay, Reduce has gone ahead to unilaterally refuse this and has gone ahead to bring these de-extinction processes to life. And as of now, we are unsure of the damages it poses to the environment or to the biosphere. And that is another of our concerns. Again, our other argument and our final argument is that the precautionary principle justifies Anekoyon's refusal. Now, the precautionary principle was stated in Principle 15 of the Rio Declaration, and I quote, "Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation." I repeat for emphasis, where there are threats of serious or irreversible damage. In this case, we've been able to establish that, yes, indeed, there are threats of serious or irreversible damage by virtue of the fact that the necessary environmental impact assessments have not been fully done and done well. If it must be done, it must be done and done well to the nearest degree of elimination of any subject matter which may arise as a result. And this is our fear. And we therefore humbly request this court to adjudge and to declare that the precautionary principle has been breached upon by the respondents in today's matter, etc. If the court will so please, I shall cede the floor to co-agent to handle issues 3 and 4 in the absence of any questions.
I have one question for you. I think I'll make the other comments at the end of everyone's presentation. But the loan agreement, right? Doesn't genome sequencing constitute scientific research? For which reason it should be covered under the prior informed consent that you are making reference to?
Much obliged. We argue that yes, while genome sequencing We argue that yes, while genome sequencing may be qualified under this research, the law makes it clear, and the ambit of the law is clear. The law is the law, and the letter of the law is the letter of the law. It says that there must be specificity with regard to anything that comes from prior informed consent. All the agreements which are listed and everything that ensues should be properly itemized and documented for the purposes of reference.
But you did enter into the agreement. Is that so?
Yes, please.
And you knew all these things that should have been specified, but you didn't.
To the effect of that, we will respond that the agreement was signed in 2009. The advancement of research up until that point has been quite drastic. However, the intendment of the law does not change. If informed consent must be sought at the beginning, it must equally be sought at the end, especially when the terms have been changed and have been varied by the course of time. With respect to this, we also respond that Anekoyon voiced its objections from the very beginning when readers made public declarations to the effect of beginning the genome sequencing. They voiced their objections to it. Therefore, we argue that readers ought to have sought again prior informed consent. And we have already established that they had the right to refuse as well.
All right, so my question is around the precautionary principle, your argument around the precautionary principle. So how does an absence of an EIA, that's environmental impact assessment, establish certainty in your argument for precautionary, around the precautionary principle? Because your argument is that there might be a distraction of the ecosystem. Okay, should they go ahead with it? So how does an absence of environmental impact assessment establish that certainty? Do you have references to any particular examples of such experiments that led to destruction of the ecosystem?
Right, so this will quote the decision of this very court in the pulp mills on the River Yoruba case. And the court may be interested in the brief facts. What happened was that the applicant in that matter had sought to prevent the respondent from setting up pulp mills on the River Uruguay, which was of mutual benefits to all of them. Now, despite the fact that they did conduct initial environmental impact assessments, what further went on was that the court established a very important principle, that this environmental impact assessment must be done periodically, especially as the project continues. To this effect, the respondent in that matter failed to do that, and the court adjudged against them.
I don't want to drag this, but the absence of an environmental impact assessment, does it establish any certainty that there would be destruction of the ecosystem should the respondents go ahead with a de-extinction experiment?
Sorry, could you rephrase that better?
The absence of an environmental impact assessment, does it establish any certainty that there would be an ecosystem destruction should readers go ahead with their experiment? Because the reference you made is reference of an EIA that necessarily does not talk about destruction of the ecosystem.
So to that we say no, but it is advised that it be done for the purposes of protecting and preserving the environment as per CBD's Article 1, which provides that the first and foremost objective of the CBD is for the purposes of conservation and the sustainable use of the environment. Much obliged. I shall see the floor to co-agent.
Mr. President, Your Excellency, I'm a co-agent for the applicant, and I'll be presenting on the third and the fourth issue. If you please support me, I proceed with my presentation. So the third issue, which is with the whether as initial matter, the use of DSI for de-extension is biotechnology for the purposes of Nagoya and CBD protocol. Respectfully, the applicant submits that indeed the use of DSI for de-extension is biotechnology for the purposes of Nagoya and CBD protocol, and as such, this benefit obligation is being triggered. To fully argue on this point, we'll be making three submissions. That is, A, de-extension involves the application of biotechnology as defined under international law. B, that CBD Nagoya Protocol COP Decision 16.2 has classified de-extension as biotechnology. And finally, that Redo's attempt to exempt de-extension from the scope of biotechnology is unfounded in law. Your Excellencies, to proceed with my first submission, that is, de-extension.
Can you give us the brief facts of the case?
Yes, please. So, the brief fact of the case is benefited from the use of genetic resources as it houses the royal panther, and it's also exhibited the royal panther, and it make it possible for viewing for premium fees. This is also seen as it generates over $130 million over the years. And also, moving to my second submission, that is Environmntal Park is a commercial entity. Readers argue that per I6 site, it is classified as non-commercial since the provisions have stated that zooing, garden, and botanical are not commercial activity. However, CBD Decision 16.2 has clearly stated that any entities that follows under these two sectors, that's biology, technology, and animal breeding, they are obliged to follow the fair and equitable sharing conditions stated. And this fair and equitable sharing, they will be used for they'll be used in promoting the environmental condition and also promoting the use of biotechnology system in the other countries in the world globally. Thus, Reynolds' refusal to make contribution is not in line with their provisions in their treaty that they agreed to. Moving on to my third submission, that is it meets the financial threshold and also its obligation is being triggered. Looking at CBD Decision 16.2, it has clearly made provision that any entity that follow under these two classifications, that is $20 million in its assets, $50 million in its sale, and finally $5 million in its profit, is obliged to give 1% of its profit or 0.1% of its revenue to CaliFund. Thus, Senior Animal Park falls under this financial threshold as they produce about $130 million in its annual revenue. And this is evidence enough that their argument that they do not take charges, it's a non-profitable organization, and that it is basically for ecological restoration is not founded in law, since the CBD provision that they assented to or they agreed to has made provision that they fall under the sectors that is biotechnology and animal breeding is also part of the sectors that they are supposed to make contribution to. Moving on to my final submission for my issue 4, that is radio's defense is unfounded in law. As clearly stated earlier on, Signal Animal Park is a DSI user as explained in CBD Decision 16.2, and also it is a commercial entity as it falls under the sectors listed in CBD Decision 16.2 Annex, and also it's obliged to follow its financial duties. It's obliged to its fair and equitable duties stated in CBD Decision 16.2. If the court permits, I would like to make my prayers. We pray this honorable court to adjourn and declare that Radios is in line with the CBD. Radios action is in line with CBD as it refused to the consent of Radios. We pray this honorable court that Radios declining of consent to the use of CBD for the use of fossil for the de-extension is in line with the provisions of CBD, that Reynolds needed to seek Anokaya's consent before using of the fossil, and also that Reynolds de-extension activities involved biotechnology, and also Signal Animal Park is a DSI user and it's engaged in commercial activity. We pray that the court will let Reynolds make reparation and compensation towards Anokoyo for breaching its obligations under CBD. Thank you.
Thank you. I think I have just one question for you. I'll make subsequent comments when both teams are done. In terms of your client's national legislation, didn't that come into force after the respondents' clients had already moved forward with their research? And so how do you in one breath try to bind another sovereign state with your domestic law?
Please, can you frame the question again?
So in short, your client's domestic law came into force after they realized that the respondents' clients had already taken certain steps which you objected to. You agree with me, right?
Sorry. Yes, sir.
So I think the purpose of this exercise is to build your skills. So just be confident and then let's engage. Because I'm not done scoring you. That's what I'm asking
Yes,
you
please.
questions.
Okay.
Yeah. I'm saying that your national legislation came into force after the respondents' clients made certain moves that you didn't agree with, right?
Yes, please.
And so, is it the case that you are trying to restrain them by falling on your domestic law?
No, please. Because the Nagoya Protocol that was signed by the two parties, they make certain provisions, they made provisions that both of them agreed to. Now, the coming into force of the CBD decision 16 and 2, they also assented to it, and they all agreed to be bound by it and follow it. As such, and in Vienna Convention of Law of Treaty, any treaty that is being made, the party has the right per Article 31 3b that to go ahead to make other laws that will help in aid development. That they follow these laws when they brought the CBD decision 16 into force. Thank you.
The respondent team.
Mr. President, Your Excellencies, and may it please this honorable court, my name is Ugochukwu Ezine Roslyn, appearing on behalf of the respondent, the state of Rivers, and in the next 12 minutes, I will be addressing issues 1 and 2 regarding prior informed consent and Anakion's refusal to consent to the de-extinction project. And my co-agent, Gabriel Tete, will be addressing this court on issues 3 and 4. Your Excellencies, on the first issue, which is whether readers complied with or violated the prior informed consent obligations of the CBD and the Nagoya Protocol, our submissions proceed on 3 grounds. 1, that the loan agreement constitutes prior informed consent. 2, that the 2009 access to the fossil falls outside the Nagoya Protocol's obligations in Article 6.1 and is consistent with the principle of non-retroactivity. And 3, that the extraction of DNA from a fossil does not require readers to seek prior informed consent. With Your Excellency's permission, I shall now proceed with my first ground.
For the record, kindly state your name.
My name is Ugochukwu Ezine Roslyn.
Please spell it.
UGO
CHU.
KWU.
And then the surname.
Sorry, that's my surname.
That's the surname. So what's the first name?
Ezine, EZINNE.
Thank you very much. Can you take us through the brief facts of the case?
Your Excellencies, this case is between 2 states, Anakion and Rivers, concerning the royal panther, which has been extinct for 6,000 years. And in 1901, the best preserved fossil was found in what is now the territory of Anakion. This fossil was loaned to Rivers in 2009 for a loan agreement for the purposes of education and scientific research. And this fossil, the information generated from the fossil, was used to commence a de-extinction project, which gave birth to 2 panthers, Ixchel and Examiner, which are being housed in the Sydney Animal Park. This court is called upon to consider whether readers complied with or violated the prior informed consent obligations of the CBD and the Nagoya Protocol, whether Anakion's refusal to consent to the de-extinction project goes counter to the objectives of the CBD, whether DSI...
Are you stating the issues as part of the facts?
Yes, Your Excellencies.
Okay.
Whether DSI used for de-extinction is considered as biotechnology, and whether the Sydney Animal Park is a commercial entity and therefore a user of DSI. With Your Excellency's permission, I shall now proceed with my first ground. Your Excellencies, on my first ground, that the loan agreement constitutes prior informed consent. Under Article 15.5 of the CBD, access to genetic resources is subject to the prior informed consent of the country providing the genetic resource. Readers complied with this obligation through the 2009 loan agreement, as there was no prescribed form which allowed the parties to make up their own consent requirements. ANECAN imposed no limitations on research scope, making the consent that was granted broad. They cannot narrow or withdraw consent that was clearly granted at the time, and by virtue of Article 26 of the VCLT, that is the Vienna Convention on the Law of Treaties, agreements must be kept and honored in good faith. Your Excellencies, on my second ground, Daridas' 2009 access to the fossil falls outside the Nagoya Protocol's obligations in Article 6.1 and is consistent with the principle of non-retroactivity. Your Excellencies, the applicant submits that the utilization of genetic resources happened after the Nagoya Protocol's entry into force. However, it is our submission that although the Nagoya Protocol was entered into force in 2015, the utilization of genetic resources involves research, meaning that the loan agreement contemplated the utilization of genetic resources. As utilization of genetic resources, per Article 2 of the Nagoya Protocol, involves the research on the genetic and biochemical composition of a genetic resource. Your Excellencies, this fossil was accessed by Readers in 2009, prior to the party's ratification in 2015, and the treaty does not apply retrospectively because it did not intend to, and the parties did not mutually and explicitly agree to retroactive application of the treaty by virtue of Article 28 of the VCLT. And per the case of Greece and Britain, the court held that obligations must attach to conduct occurring after a treaty's entry into force. Your Excellencies, on my third ground, that the extraction of DNA from a fossil does not require readers to seek prior informed consent. Your Excellencies, the extraction of DNA amounts to utilization of genetic resources, which was contemplated by the loan agreement in paragraph 15 of the record. ANACION submitted that due to the utilization happening after the Nagoya Protocol's entry into force, a new prior informed consent should have been sought by readers. However, it is our submission that the loan agreement contemplated utilization, and therefore, readers is not required to seek prior informed consent again, as the utilization of genetic resources falls under the scientific research purpose of the loan agreement. And scientific research, per paragraph 1C of the Recommendation on Science and Scientific Researchers, published by the United Nations Educational, Scientific and Cultural Organization, UNESCO, involves the observation, analysis, and experimentation to generate new knowledge. And the extraction of DNA from a fossil amounts to this experimentation, and the DSI that was made publicly available in paragraph 28 of the record amounts to knowledge. With Your Excellency's permission, I shall now proceed with my second issue. Your Excellencies, on our second issue, which is whether ANACION's refusal to consent to the de-extinction project goes counter to the objectives of the CBD. Your Excellencies, the applicants submitted that based on their state sovereignty, they have a right to refuse consent to de-extinction. It is our submission that although they have a right as a sovereign state to refuse de-extinction, every state is sovereign and has a right to enter into treaties voluntarily. No state is being forced or coerced to enter into a treaty. And state sovereignty is an attribute of every state. And once a state has entered into an agreement, they are legally bound by the objectives of that treaty. ANACION cannot use sovereignty to avoid adhering to the obligations of the CBD that they voluntarily entered into. Your Excellencies, Anakion submitted that RIDAS's the de-extinction project shifts attention to the revival of species instead of conservation. However, it is our submission that de-extinction still serves as a way of conserving biological diversity, as the technologies adopted for the de-extinction project can be used to help other currently and threatened endangered species. Technology like CRISPR, which is gene editing technology, can be used to insert specific survival traits into other species, other endangered species. An example of that is the black-footed ferret, where scientists use CRISPR technology, or they are currently using, to enhance their ability to survive by modifying their genes. And another case example is the north white rhino, with only 2 females left. Scientists are using CRISPR technology to correct abnormalities in their stem cells to ensure healthy functional eggs will be created, and with the help of IVF to prevent de-extinction in this species. Your Excellencies, other advantages of de-extinction includes that it corrects the wrongs of the past. The Blythe people were involved in the hunting of the royal panther, which led to its de-extinction, among other reasons. That's per paragraph 7 of the record. Your Excellencies, it restores the wrongs of the past, and it restores lost ecological functions. And lastly, this de-extinction project provides employment. In paragraph 36 of the record, RIDAS's long-term plan is to introduce succeeding generations into government-owned areas, and small safari companies will be operated, which will be operated by the Panthera people, will lead jeeps for the viewing of these panthers, thereby serving as a means of employment for the Panthera people. Your Excellencies, Article 12 mandates that parties should encourage research that contributes to conservation and sustainable use. De-extinction provides information on how to revive extinct species, and the same approach, as I've earlier stated, can be applied to endangered species to prevent future extinction. Your Excellencies, it is for these reasons that the respondents respectfully submit that RIDAS complied with the prior informed consent obligations of the CBD and the Nagoya Protocol, and Anakion's refusal to consent to the de-extinction project goes counter to the objectives of the CBD.
Just one question for you. What is informed consent? Because you've made reference to that, and you also admitted that the language in the contract or the agreement was broad, and they are also arguing that the contract did not include what you or what you set out to do or what you're already doing. So what do you think is informed consent?
Your Excellencies, prior informed consent is the collective right of a group of people to decide whether and how projects affecting their culture, their territory, their lands, and their resources may proceed. And this definition was given by the United Nations Collaborative Program on Reducing Emissions from Deforestation and Forest Degradation in Developing Countries Handbook on Free and Prior Informed Consent. Your Excellencies, the prior informed consent obligations of the CBD are found in Article 15, which states that access to genetic resources is subject to the prior informed consent of the country provided the genetic resource. And at the time, it was the CBD that governed this loan agreement, and the CBD gave no specifications on what the loan agreement or and the CBD gave no specifications on how access should be given. It is the Nagoya Protocol that gave these specifications, but as I said earlier, they do not apply to RIDAS in this instance matter. Therefore, RIDAS has complied with the prior informed consent obligations of the CBD. I shall now yield the floor to my co-agent, Gabriel Tete, who will be addressing this court on the third and fourth issue, respectively submitted.
Mr. President, Your Excellencies, may it please this Honorable Court, Gabriel, Tete, Lawete, appearing as co-agent on behalf of the respondents, readers. In the next 18 minutes, I will address this court on the third and fourth issues. And with the kind permission of the court, I'll now proceed to my substantive arguments. Most grateful. On the third issue, this court is called upon to determine whether digital sequence information, hereinafter referred to as DSI, when used for de-extinction, constitutes biotechnology under the Nagoya Protocol and the Convention of Biological Diversity, hereinafter referred to as the CBD. Your Excellencies, while the applicant answers this question in the affirmative, the respondent begs to differ and would advance 3 grounds in support of our argument. These are: 1, that biotechnology under the CBD requires the use of a biological system, a living organism, or their derivative. And 2, that while the applicant seeks to characterize DSI as a derivative of a living organism, the definition of derivative is stipulated in the Nagoya Protocol, and DSI falls outside that scope. And 3, that the Conference of Parties practice, hereinafter referred to as the COP practice, treats DSI separately from biotechnology. Your Excellencies, now to the crux of my arguments. On the first ground, we submit that Article 2 of the CBD.
Can you kindly take us through the brief facts?
Very well, Your Excellencies. The matter today concerns a dispute between Anarchion and readers over prior informed consent obligations and benefit sharing obligations under the CBD and the Nagoya Protocol. Sometime in 2009, a fossil which was shared between Anarchion and readers, but the best preserved ones found in Anarchion, was loaned to readers for scientific research purposes. Based on this loan agreement, readers extracted DNAs from the fossils and created a DSI. This DSI was made publicly available, and Cells Co., a private institution, used that DSI to create 2 new panthers by bringing back the extinct panthers which once lived on the earth. Your Excellencies, my argument as the co-agent is to oppose the allegations that DSI that we used for the de-extinction process amounts to biotechnology. Our argument is that Article 2 of the CBD defines biotechnology as a technological application that uses a biological system, a living organisms, or derivatives thereof to make or modify products for specific use. Your Excellencies, it is important to note these operative words: use of biological systems, living organisms, or their derivatives. Your Excellencies, the DSI is not a biological system. It is neither a living organism. And as this court established in the pulp mills over the River Uruguay case, that treaty tests are supposed to be appreciated in their ordinary meaning per Article 31 of the Vienna Convention. We beseech this court to adjudge that DSI, having been established that it's not a living organism and it's also not a biological system, then it doesn't amount to biotechnology. And this brings us to our second ground. Now on the second ground, the applicant seeks to characterize DSI as a derivative because it was extracted from living organisms. Your Excellencies, we recognize the fact that at paragraph 31 of the record, it is stated that we use the DSI of the North American cougar, which is still alive. Your Excellencies, that, however, does not make DSI a derivative. Article 2 of the Nagoya Protocol is very intentional and stipulative on the definition of derivative, and it refers to a naturally occurring biochemical compounds resulting from the genetic expression of a genetic material. Your Excellencies, DSI is not a naturally occurring biochemical compound. It is an information extracted by humans from these organisms. In fact, the Secretariat to the CBD in its guide to the Caliphate is very clear on the definition of DSI, and it defines DSI as the digital representation of genetic material such as DNA and RNA sequences, and potentially other linked data like amino acid sequences and molecular structure. Your Excellencies, this is so clear that DSI is not a derivative. Considering this same court's decision in the Kasikili or Sidudu Island case between Botswana and Namibia, where the court held that when a treaty is explicit on a particular term or a definition, general understandings are not recognized, and that treaty's definition overrides general understanding. So we do recognize, we do acknowledge that DSI was extracted from a living organism. I mean, that's the North American cougar, and not for the fossils. However, given that the Nagoya Protocol is stipulative on what amounts to a derivative, and DSI falls outside that scope, then DSI cannot be said to be a derivative. Finally, on the third ground, on the third issue, we submit that the Conference of Party Practice treats DSI separately from biotechnology. Your Excellencies, the COP practice explicitly does this, particularly at the COP 13. At decision XIII Clause 6, the parties of the CBD were invited to submit views on the potential implications of the use of DSI on genetic resources. And at COP 15, that's 6 years later, decision 15.9 was adopted, and it established a new multilateral mechanism for benefit sharing from DSI. Your Excellencies, this is so intentional. This is to the effect that DSI is different from biotechnology, and that is why the new multilateral mechanism was created for it. If DSI were to be treated as biotechnology, there wouldn't have been the need for this. And that is why we submit that considering this very court's decision in 1997, that's the Gapchikovo-Nadimaros project case, where the court held that subsequent state practice is relevant when it comes to treaty interpretation. That is when the court was trying to emphasize on Article 31, Clause 3b of the Vienna Convention of the Law of Treaties. We urge this court and beseech Your Excellencies to respectfully adopt the COP practice that treats DSI separately from biotechnology. Your Excellencies, we therefore, in light of all these, submit that DSI used for de-extinction is not biotechnology under the Nagoya Protocol and the CBD. Your Excellencies, respectfully, in the absence of any questions, I'll proceed to the fourth issue. Very well, Your Excellencies. Now, the fourth issue appears in a dichotomy. This court is to determine whether, first of all, the Sydney Animal Park is a user of DSI under CBD Decision 16.2. And secondly, to determine whether the Sydney Animal Park is engaged in any commercial activity currently listed under CBD Decision 16.2. For both parts, the respondent answers in the negative, and our reasons are as follows. For the first part, we submit that the Sydney Animal Park is merely housing the panthers. Given that the CBD Decision 16.2 does not provide an explicit definition for the term user of DSI, which the applicant actually proved this court wrongly by saying that the CBD Decision 16.2 does, we acknowledge the fact that CBD Decision 16.2 does not provide that definition. So, we rely on Article 2C of the Nagoya Protocol, which defines utilization of genetic resources as the research and development carried on the genetic or biochemical material of a genetic resource or metabolism. Your Excellencies, it's simple. When we take the object of that definition from physical material to digital sequence information, the definition of the term user of DSI becomes clearer, and it refers to any entity that uses genetic or digitalized genetic data to unlock its genetic potentials, either through applying it, synthesizing it, or sequencing it. Your Excellencies, we submit that the Sydney Animal Park does not do any of this. In fact, at paragraph 33 of the record, it is clear that the Sydney Animal Park is merely housing the panthers. Your Excellencies, the generation or the extraction of the DNA to create the DSI, per paragraph 16 of the record, was done by the National Museum of Readers. The utilization of the DSI to create the panthers was done by a private-owned institution called SALSCO, per paragraph 31 of the record. The Sydney Animal Park was only contracted to house and care for these panthers. So to characterize the Sydney Animal Park as a user of DSI is so flawed, and as such, the applicant's claim does not hold. Your Excellencies, we furthermore submit that the CBD Decision 16.2 itself supports this line of understanding, because at paragraph 2 of the annex, it states that all users of DSI are supposed to share benefits, thereby limiting obligations to contribute to the Caliphate to only active users, those who handle the DSI actively. Your Excellencies, Sydney Animal Park does not even handle it at all. Paragraph 9 of the annex further goes on to say that public research institutions and education facilities are exempted from monetary contributions to the Caliphate. Your Excellencies, this kills it all. It makes it clear that the Sydney Animal Park, having been characterized as a zoological garden and a nature reserve, and as such, it is a research institution and a public research institution, it cannot contribute monetarily to the Caliphate, and as such, it is not a user of DSI. Furthermore, Your Excellencies, per paragraph 10C of the record, it requires database operators to collect metadata such as country of origin, reinforcing that users under the CBD Decision 16.2 are only those who actively handle, utilize, sequence, operate with DSI, and not merely those who care or house organisms that were created with DSI. Your Excellencies, we therefore submit that the Sydney Animal Park is not a user of DSI under CBD Decision 16.2. Now to the second ground for issue 4. Your Excellencies, for the second part of the fourth issue, this court is to determine that the Sydney Animal Park, whether or not the Sydney Animal Park is engaged in any commercial activity currently listed under CBD Decision 16.2. Your Excellencies, having established that the Sydney Animal Park is merely housing these panthers, it is neither a pharmaceutical, it is neither a nutraceutical institution, it's not engaged in cosmetics, it's not engaged in biotechnology, it's not engaged in animal and plant breeding, it's not engaged in laboratory services. Sydney Animal Park has nothing to do with AI, so Sydney Animal Park does not fall within any of the listed sectors under Enclosure I. Your Excellencies, the Enclosure I lists these sectors, and paragraph 3 makes clear that users are only those who generate benefits from it. Your Excellencies, we've established that the Sydney Animal Park is not engaged in any of these things. And considering the expression, the principle of expressio unius est exclusio alterius, where this court in the territorial dispute case versus Libya and Chad, somewhere in 1994, established that when there's a set list of sectors that do not fall within that list are excluded. Your Excellencies, enclosure I starts with the statement indicative list. This shows that the list is indicative, and it is clear from the bottom part of enclosure I that the current list is under review considering the International Standard of Industrial Classification. And this International Standard of Industrial Classification classifies the Sydney Animal Park as a zoological institution and nature reserve. Your Excellencies, just as our minister said at paragraph 20 of the record, it will be a sad day for the applicants to characterize the Sydney Animal Park as a sector engaged in commercial activity. And as such, the Sydney Animal Park is not engaged in any commercial activity currently listed under CBD Decision 62. Your Excellencies, in short, our argument for the third and fourth issue is that the Sydney Animal Park is not a user of DSI under CBD Decision 62, and it's not engaged in any commercial activity currently listed under CBD Decision 62. With the court's kind permission, I would now proceed to our prayers. Most grateful, Your Excellencies. Your Excellencies, we pray this court that in light of all the stated claims, this court should adjudge and declare that, first of all, regarding prior informed consent, Redos complied with the prior informed consent obligations of CBD Decision 62, and as such, Anakion's refusal to consent to the de-extinction project is counter to the CBD objectives. And secondly, that regarding benefit sharing obligations, the Sydney Animal Park is not a user of DSI under CBD Decision 62, and it is not engaged in any commercial activity currently listed under CBD Decision 62. Under CBD Decision 62, respectfully submitted.
Okay, so I have one question. I believe lawyer Mensah raised a concern about there being no environmental impact assessment done in relation to the de-extinction project that you are carrying out. How do you respond to that?
Your Excellencies, we acknowledge that international law, specifically international environmental law, requires environmental assessment. Your Excellencies, while the record is silent on whether or not that was engaged by Redos, we invoke the fact that, per paragraph 31 of the record, the actual de-extinction process began with Salus Co. Generation of knowledge, which is the DSI, intangible data, was the only thing we did, and it falls within the scope of the loan agreement that was granted legally with consent to us. Your Excellencies, we therefore leave the environmental assessment to Salus Co., which is a private institution, and as such, as a state, we have no obligations attached to that.
Can you justify your non-obligation as a state when it comes to overseeing that an environmental impact assessment is done, even though a private entity is perhaps responsible? How about the state's oversight responsibility over that?
Your Excellencies, once again, the record is silent on the fact that, on whether or not environmental assessment was done. However, Your Excellencies, this private institution living in our country means that we are to an extent responsible for what they do. However, concerning state responsibility under international law, Your Excellencies, there's nowhere in the fact that states that we have an effective control over silo school. And even if that is the case, Your Excellencies, we humbly request and seek this court to recognize the fact that that particular matter is not in contention, in that the record is clear on the questions that are posed to us, and our response are only to the allegations the applicants are raising against us. Thus, having established and satisfied that all the claims they've leveled against us are flawed and do not carry any weight, we beseech this court to adjudge and declare in our favor. Respectfully submitted. Thank you.
Okay, so I just want to make some initial statements and I'll cede the floor to my colleagues to also make their comments. First of all, I would like to say that I'm proud of everyone here, the active participants on both sides. Kindly give them a round of applause. It's not easy standing before your own colleagues to actually deliver, and I think both sides have done a good job. And also, when you know in this profession your clients may have done something wrong, but you have to find a way, and I think they've all tried in one way or another to come out with some ingenious ways of making their points. Now I have a few comments. So for instance, when you are making reference to some other document, right, you have to seek the court's permission before you quote from it. Sometimes when you make reference to a case in court, you can say, oh, you are relying on Awuni versus Waek, right? You have to state the full citation, and sometimes there are some judges that would ask whether you have a copy of the case, so you have to be prepared for anything. That's one of the things I want to talk about. And also, when you are introducing yourself, to make things very simple, when you rise, you say, may it please the court. So I'm using myself as an example. May it please the court, Kwame Boamadakun for the applicant or for the respondent. And then you simplify things. Because if you fumble with that part, this whole thing is a mental game. So if you fumble with that part throughout for a while, you'll be off your game. Also, there's a thin line between oratory skills and advocacy. I think everyone here is a good orator. You've demonstrated it. Now, the little bit that is left that requires polishing, even for those of us in the profession, every now and then you have to polish up. It's not, you can't be perfect. You have to polish up. You have to polish up your skills. And so, with the advocacy bit, right, you have to be able to convince the judge. I think you guys have done your, okay, maybe we'll talk about that after your rebuttals, but you can have solid points, but the way you deliver it, you have to be convincing. If you are just rattling, I can hear you, but you don't know the mood I'm in, right? Judges are human beings. Maybe he's already annoyed before he got here, and then you are just rattling, fine. He's not listening to you. You've made your points, but you have to convince him, because you have your clients seated in the well of the court or in the gallery. You have to also show them that you are earning your money as a lawyer. So that's when your advocacy skills come into play. You have to know when to pause. If need be, there are some lawyers that display, they turn around and look. That also shows some bit of confidence. Okay, so that's what I'll say for now. After your rebuttals, I'll just see if I have one or two more gems to drop. Okay, so we'll hear the rebuttals.
Much obliged, Your Excellencies. On the rebuttals, we have 5 minutes, and in that time, I seek to make 12 rebuttals against the argument of the respondent in this matter. The first one is that on the sovereignty and the right, Article 15.2 is an endeavor obligation. It is not a mandatory grant of access. It explicitly states that facilitation is subject to national legislation.
Article 15.2 of, is it your
of the
SRC
CBD.
Constitution?
My apologies. Article 15.2 of the CBD states that it is an endeavor obligation and not a mandatory grant of access. And it explicitly states that facilitation is subject to national legislation. Now, this will beg another question that if it is so that national legislation, isn't it then that we are imposing our national sovereignty over the conservation efforts which are being placed by the respondent? To that we argue no. What we are instead doing is that we claim that the biological material in itself belongs to Anekoyon. To this effect, the respondent ought to seek and come together for mutual cooperation, thereupon enhancing the shared benefit system as was defined in Article 1 of the CBD, which makes it clear that the objectives of the CBD are threefold. 1, conservation; 2, sustainable use; and 3, mutual benefit sharing. To enhance this, we are positing that they ought to come together with the applicant in this matter to address the concerns, especially when the applicant has raised salient concerns against it. On our next rebuttal, we argue that on the non-retroactive argument, the respondent leans heavily on the Vienna Convention, Article 28, and arguing that the access happened in 2009, that is 6 years before the Nagoya Protocol existed. Our argument is based on the Bonn guidelines of the Nagoya Protocol, and it states that our argument is premised on the fact that the utilization or the genome editing and subsequently the restorative effort of reduce are what is in question, and not necessarily the argument of the loan transfer which gave them the right to access the material in the first place. So that is the center of our argument, not on the loan transaction or the movement of the genetic material to reduce, no. However, on the utilization of the genetic material which began after the Nagoya Protocol came into office or came into force. Now again, on the non-commercial argument of the Sydney Animal Park, the respondent argues that the Sydney Animal Park is a conservation facility and a non-profit, and thus it is exempt from the commercial animal breeding sector decision in decision 16.2. We argue that according to the record, paragraph 45, the park makes $130 million a year, and they charge a specific $40 panther observation fee. This is commercial exhibition and monetization of a genetic derivative. Under this argument, we follow that regardless of their non-profit status, they are engaged in a commercial activity for the purposes of tourism as well. On the article paragraph 45, it further stated that they are making $7 million in food, drink, and gift sales, $4 million in panther observation fees. And the Sydney Animal Park itself has assets in excess of 20 million US dollars. If this is not commercialization, then there is no other interpretation which can be put to it. And on our final rebuttal, that is specifically on the definition of the genetic resources, the respondent argues that a 6,000-year-old fossil is merely a mineralized rock. It has no biological material whatsoever. It's not a derivative. It has no life in it. To this, we respond that this fossil, according to clarification Q12 of the record, thank you. According to clarification Q12 of the record, confirms that the fossil provided DNA, yes, the fossil provided DNA of sufficient quality to allow for the construction of a genome sequence. If the material can be used to build a live code, it remains a genetic resource under Article 2 of the CBD, and furthermore, the Nagoya Protocol covers derivatives under this same definition. Thus, the digital sequence information which has been extracted from the bone is a derivative of anekoyon's heritage and is subject to the same sovereign protections. The court may allow me to proceed, or is there any other questions? Okay, thank you.
There were a lot of points to put across, there were a lot of points to share and deliver, but there should be an organization to it as to what is more important and what is more relevant as compared to the other points. I feel like it could have been done better on both sides. When it comes to, especially when you mentioned your rebuttals, you had a lot of rebuttals to give within a limited time. 5 minutes is not enough to give 12 rebuttals. I think the best thing to have done is to organize it in accordance as to how you want to give it in relation to what they said, in order of importance, as I said earlier, so that even if the time has run out, you've made your most important points first, and we can intuit the rest from the remaining. I believe you understand me. And in regards to the respondent side as well, I also feel like in terms of getting your points across, most of you were focused on finishing the point rather than getting your points across. I don't know if you understand the difference between the two. Most of you wanted to finish the points that you have written down, or to get across the points that you have prepared in your mind that, okay, this is what I'm going to say, this is what I'm going to say. You wanted to finish saying that rather than focusing on getting your points across, meaning the information that you're trying to get across to us. Rather than getting that across, you were more focused on finishing what you had to say. But all in all, I think both teams did very, very well, and yeah, that's all I have to say.
I think what my colleague touched on is very important. You may have prepared maybe 4 or 15 points that you want to deliver, but knowing very well that this is a timed competition, maybe you should put your best foot forward. Your strongest point should come out, so that once you've run out of time, you probably would have convinced the court. It's the same thing in real life. Like, you don't have all day in court. It's for a limited period. So in advocating for your client, you should ensure that you put your best foot forward. And another thing that I should have touched on earlier is to do with the expressive movements. So when you're in court, yes, you're allowed to have a bit of hand gestures, but it shouldn't be from beginning till the end. You have to also be aware of where you are. I think that's also something that, but I think all in all, everyone did well. I'm glad that you took up the challenge to face us, face your colleagues, and deliver. I'm proud of you guys.
All right, so thank you, my colleagues, for your comments. So they have talked about articulation and how you delivered and all of that, so I'm not going to touch on that, so thank you. I would touch on international environmental law, so environmental law in general, and also international law and practice. So I think you have done quite well, trying to make references to the treaties, and then the customary international law to back up your arguments. So that's good. And I'm also happy you made references to some environmental principles, precautionary principle, environmental impact assessments and all that. So from my perspective as an expert in the field, I think you guys have done quite a good job. But what I would have, my expectation, being a bit higher, is that you could have made more vivid references to the various treaties that you refer to and back up your arguments, because at the international law practice is mainly the treaties, the customary international law, and then the general principles and all of that. So they must stand out. I think I observed some of you making some precedents of other cases. In international law, we are not obliged to follow precedent, so please be aware of that, although we may consider them, right? So please be aware of that and limit precedents in your, to back up your arguments or draw attention to your arguments. So generally, well done. Thank you.
Sorry, it's like I'm talking too much, but I want to particularly now specifically commend each and every one of you. So Darren and Gabriel had confidence, which I admire. Ujo Chukwa was organized. I don't know if you noticed. She had some notes in front of her. The point of Moot is not to come and read to us or memorize and come and rattle. She tried to express herself, and then where she felt like she couldn't really remember certain things, she made reference to whatever she had written down. She wasn't reading to us. It's possible she had memorized it, but then the delivery. Once I'm convinced that you are convincing me or advocating for whatever argument you are trying to put forward, you sold me. I may be wrong, but... And then your name is a bit long. Can you tell us your name again? Judelia. This is the first time I'm hearing it. So one thing I love about Judelia's performance is that even though at a point she fumbled, she showed some resilience. She didn't give up. She kept going. So I think you have to combine all those attributes from the four competitors and then apply them in your personal lives and in your legal career. Thank you very much.
So there's a huge market, I would say. Huge market in the sense that wherever there's infrastructure development, there's also an environmental impact, right? And so environmental impact assessment has a whole regulations, around it, and therefore has space for legal practitioners. So that could also be legal consultants, those who have expertise in the field. There's also the climate and then clean energy space that is also really developing very, very fast across the world and in Africa. So wherever there are climate and then renewable energy projects, these are environmental related issues. So you need legal experts who understand environmental law in order to help clients, navigate. There's carbon credits, carbon, projects that are recently we have the EPA Act, the new act that has established the Carbon Management Office, okay? And this office has a whole lot of regulations when it comes to carbon offsetting projects. There is industries that are into manufacturing. They all would have environmental impact, okay? So they need legal people to advise them on compliance issues. So yes, there's a lot. But if you're also looking at the international environmental law practice, that has to do with nations, that, and then of course some other international organizations. So in international organizations, there are quite good prospects. If you talk about UNEP, That's the United Nations Environmental Program. They have a lot of projects and programs ongoing, and they need people with expertise in international environmental law to support them, right? And when it comes to negotiations at the international level, climate, how many of you have heard of the Paris Agreement or the Paris Accord? Yes. So there's a lot of negotiations ongoing. There's a lot of compliance that has to be done at the national level, right? So there are good prospects, and the field is also emerging with new. You're just hearing about the the biotechnology, the de-extinction, and all. These are interesting projects or ideas that are all coming up, right? So you can see per the case that we have very complex, and so you still need people who have expertise in the environmental space to be able to navigate. So yes, there are good opportunities, I can say. Thank you.
I think my colleague has said it all, but to add to that, there's this emerging trend whereby a lot of international organizations, before they lend you, for instance, some financial support, they want to know what your particular country is doing to, for instance, help reduce global warming. And every now and then you have to be sending reports. And so you need legal experts among other professionals to assist with that kind of work. So the space is always growing. As time goes on, new things come on board, and then so don't lose hope. Keep an open mind, and then just look out for opportunities. Just right now we have the internet at our fingertips, so don't wait for your school or your lecturers or your colleagues to share something with you. If you have a particular interest in a particular area of law, even if you are not interested, just be curious, go online. You might even connect with your counterparts out there, and then they'll put you on to new things that you probably never imagined existed.
So just to add on to what everybody else has said, it's true that currently in the day and age we're living, the environmental law has more impact internationally than it does nationally, but you're also forgetting that, and that's because people tend to focus on the climate, they focus on climate change, global warming and all of those things on an international scale, carbon footprints and emissions as well. But on a national scale, there's also natural resource law, which is linked to environmental law. When it comes to things like mining, when it comes to things like timber felling and all of those things, environmental law still plays a role in all of these things. So the market for environmental law, although it seems small nationally as compared to internationally, it's growing though. So in the next few years, it'll get to a point where they would be on par. If not, one would be overtaken by the other. But there's still great opportunities with environmental law, natural resource law, all of these things within the nation, that's nationally. Thank you.
Another round of applause for our judges. Excellent remarks given. Seems our national coordinator is here. And in a few minutes from now, you will know the winning team, the team that will be leaving here with the trophy, best memorial, best oralist. Right, so at this juncture, we will be giving out the certificate for participation from the teams. And so we will start with the applicant team. So the applicant team, if you could please come forward. Please, let's clap for them. They have done well. It's not easy. Clap for them.
Whether Edina Asari Ankomakweko.
Darren Foster Foley Kweku Clena Mensa. Christiana Inketia Emanuela Amwa. Judelia Law Quiz. I hope I got it correct. Esther Apiedu. Now we shall have the respondent team come in front. So, Ogochukwu Ezene Roslyn. Steve Afoku. Gabriel Tete Laweti. So the next award is for the best oralists for the Stetson International Environmental or Moot Court Competition 2026, the Ghana qualifying rounds. And it goes to Mr. Gabriel Tete Laweti. And so out of the 3 judges, Gabriel had a total score of 290 out of 300. Very impressive. Now to the next award, the best memorial for the Stetson International Environmental Law Moot Court Competition 2026 goes to Pentecost University. Ladies and gentlemen, and the winner for the Stetson International Environmental Law Moot Court Competition 2026 goes to with a total score of 572 out of 600. Team 001 GIMPA Law School. So team 003 had a total of 518 out of 600. A round of applause for them. And so before we award them with the trophy, the medals will follow. The medals will start with the medals for the team that came in second, and then the gold would follow, then finally the trophy. And so if you could have the Pentecost University team. Now to team 001, the GIMPA Law School. With a round of applause, let's welcome them and come for their medals. Now, to help us present the trophy to the winning team, we shall call upon the presiding judge to help us with that. Round of applause. Closing remarks from the national coordinator.
Good evening, everybody. As we conclude the Ghana national rounds of the Stetson International Environmental Moot Court competition, I would like to sincerely thank you all for being here today. To our teams, well done on your hard work, preparations, and excellent advocacy. You represented your schools with professionalism and dedication. To our judges, thank you for your time, expertise, and thoughtful feedback. Your role in shaping these future lawyers is deeply appreciated. We are grateful to the GIMPA Law Faculty for hosting us, and to ADO and ADO legal attorneys for their generous sponsorship, and the Stetson University College of Law for their continued support and guidance. This may be the end of the national rounds this year, but it's also the start of a next stage for our teams as they prepare for international competitions. We wish them the best in every success. Thank you all for being part of this evening's event, and have a wonderful evening. Thank you.
All rise.